Hi, my name is T.C. Rollins. I'm a bankruptcy lawyer in Jackson, Mississippi, and I'm making a video today to explain how cosigners work in the bankruptcy and the debt collection process. We have a lot of people come to us to get help with their debt, and they have misconceptions about what it means to be a cosigner. So we're making this video to explain how that works. A cosigner is created anytime two people sign up for a loan together. They could be married, they could be related people, father, son, or it could be completely unrelated people that sign a loan together. In any of those situations, there are cosigners because there are at least two people that owe that loan. And so the misconception comes in that people believe sometimes that the person that signs first is somehow more liable than the person that signs second. They'll say, well, I'm on top, or I'm the first person on this loan. They're just the cosigner. But what cosigner means is that you both owe the debt. If that debt goes unpaid for any reason, they're not going to just sue the first person. Both people are going to get sued. And so we have to take that into account when we decide how to help people with their debt. In bankruptcy, there's two different types of cases that we file to help consumers. It's Chapter 7 and Chapter 13. And Chapter 7 is the type of bankruptcy where we just eliminate your debt, okay? And let's just say there's two people on a loan, person A and person B. If person A files Chapter 7 bankruptcy and eliminates the debt, well, that only protects them. Person B can still be sued. They're not protected by the bankruptcy. They would have to file their own bankruptcy case to take care of that debt, or they'd have to pay the debt. If two married people are co-signed on a debt and file together though, as long as they file together, the bankruptcy will take care of the debt. Chapter 13 is a different animal. Chapter 13 it's tricky. It's difficult for us sometimes to help people in Chapter 13 if there's a lot of cosign or important cosign debt. So for example, if someone has a car that they've cosigned with their father on, if the son files bankruptcy, we can reorganize the debt. We can pay lower interest. We can pay it over time. We can just get a better deal, but that better deal only applies to the son. The good news is that the creditors will have to leave the father alone while the son is in bankruptcy, but the bad news is that the father will still owe money at the end of the case. Now, whatever the son paid gets applied to the loan, but normally when someone finishes Chapter 13, the car's paid off. And in this situation, it wouldn't be. The father would still owe some amount of money, the difference between the interest that was paid, or maybe even more if the son only paid the value of the car. But whatever, it could be a wide amount of money. It could be a lot of money that's owed at the end of the case. If it doesn't get paid, then the creditor can take the car back. They can still repossess the car. They couldn't sue the son for any money, but they could potentially sue the father for money. And so these are the things that we have to consider and investigate before we file a bankruptcy case. We take this very seriously to make sure to find out what cosigned debts our clients have and to give them advice on how each of those debts would be treated in the bankruptcy. And sometimes we shift our strategy based on what we figure out. I hope this has been informative. If you've got questions on how bankruptcy would work for you, or if you've got cosigned debts that you'd like to know how those would be affected in a bankruptcy, feel free to make a consultation and we'll look at your situation specifically. Thanks.